And I don't know if you all just heard that voice that I heard, which said, "This meeting is being recorded. That is because this meeting is being recorded." And thanks to Erika Rickard from the Pew Charitable Trusts for agreeing not just to share with us this landmark report, but also to record the meeting for the many people that we have heard from who are unable to make it right now, but are looking forward to watching this when they can. My name is Ted Merman. I run the Center for Consumer Law and Economic Justice at the Berkeley Law School. We are holding a series of economic justice focused events this summer. The first of them is in response to a remarkable report issued by the Pew Charitable Trust, authored by our guest today, Erika Rickard, on, as the title tells us, how debt collectors are transforming the business of state courts, or perhaps more tendentiously, she can't say it, but I can, how they are taking over state courts and using them in some cases as arms of their operations. We have on the call members of the state court system in California. We have, I think it is fair to say, dozens of people on this call who are dedicated to the cause of fairness and justice in the California judicial system. Erika has, although this is a national report, Erika has very generously agreed to focus her comments today on California, and we will have time just to give you a sense of how the next hour will unfold. Erika will give a brief presentation of the report, an overview for those who have not yet had a chance to read the entire thing cover to cover. And then we'll take questions from the audience. Please raise your hand in Zoom if you would like to be called on when you have a question. You can do that during Erika's presentation, or more likely right afterwards. I will call on people and Erika will answer questions. We will then have the opportunity, I hope, in the last 15 minutes or so, collectively to think about some of the things that we might do in the state of California in order to act on some of the data that Erika and others have presented to us in the course of the discussion. If for those who don't know, the participant button down on the bottom of your screen, if you click on that, you will have the opportunity to raise your hand, and you can click on that, and that'll put you in the queue. For those who are attending on behalf of agencies and other organizations, or I shouldn't say on behalf of, who work for agencies and other organizations, we give you the blanket disclaimer that you are speaking for yourself and not for your organization when you ask questions or offer input today. Very briefly then, let me introduce Erika Rickard. She is the inaugural director of the Civil Legal System Modernization Project at Pew Charitable Trusts. Before that, she worked at the Access to Justice Lab at Harvard with Jim Greiner, and you may well be familiar with the work there that has captured our attention in the past. And before that, she worked in the court system in the great Commonwealth of Massachusetts and was on the Consumer Debt Task Force of the Massachusetts Access to Justice Coalition. Without further ado, Erika Rickard.
Hi, good afternoon, folks, and thank you so much for having me. I'm going to do the classic Zoom faux pas of making sure everyone can hear me okay. Can you hear me okay? Wonderful. I just want to say at the outset, thank you very much for inviting me, and thank you to everyone who is participating for all of the work that you do, whether that's as an advocate, as a member of the court personnel, or any other part of the civil justice system. The work that, as Ted described, the work that we're doing at the Pew Charitable Trusts focuses on modernizing the civil legal system across the country, not exclusively on a single issue area. So we're starting with debt collection lawsuits, and I'll explain a little bit more about why. But our aim here is to really understand how we can make civil courts and the civil justice system more broadly work better for the people that it's intended to serve. So you're all a big part of that, and I'm looking forward to the discussion at the end of the presentation today. So just to give you a brief overview of the Pew Charitable Trust. So we're a public charity. We focus on fact-based research, looking at a wide range of policy areas from criminal justice to environment to health. And then the area that I work on is the civil justice system. And within that area, we have kind of three pillars of our work. And the first pillar is the one that I'll be talking about today, which is about research. So examining court trends and understanding better about who's accessing the civil legal system and who isn't and why. But there are other areas of our work as well. So one focus that we have is on kind of expanding beyond the usual suspects of folks who are familiar with the civil justice system and engaging in partnerships with other branches of government and with other sectors as well. And then the last pillar of our work really looks at technology and trying to identify both promising technologies that can be used within the court system and within the civil legal system more broadly, and then also the policies and procedures that are necessary to ensure that those technologies actually are put to best use, particularly when it comes to working with self-represented litigants or individuals who are navigating the court system with limited access to resources. So that's the kind of nutshell of our project as a whole, and I'm always happy to answer questions, but want to focus primarily on this recent report we just put out last month. My plan is to talk a little bit about what's happening today and in the wake of the coronavirus pandemic, and then to turn to the key findings of the report, both about what we learned about debt collection lawsuits, and then also about what we learned about how states are responding to the rise of debt collection lawsuits. And anytime throughout this, as had suggested, if you can find the place to raise your hand, feel free to ask questions throughout. I'm happy to pause and discuss key points or clarify anything, but I definitely want to make sure that there's time for a robust discussion, because there's a lot of folks with significantly more expertise than me on this call today. So I'm eager to get your thoughts and kind of incorporate them into what the future looks like. But without further ado, first we'll talk about, this is kind of outside of the four corners of the report into what's happening today in response to the pandemic. So as we know, courthouses are closed across the country, and there's been this range of actions that states have taken in identifying which kinds of case types to delay altogether or move online, or to proceed with as normal in a kind of more urgent fashion. And what we've been monitoring is really looking at both what the National Consumer Law Center and some industry groups have been compiling about state actions that are specifically addressing debt collection lawsuits. And the kinds of lawsuits that I'm going to be talking about today are largely consumer debt. So businesses suing individuals, whether that's for medical debt or student loan debt or other forms of household debt. But the kinds of actions that we've seen since March have really focused on post-judgment actions. So there's a range here. So Governor Newsom in California put out an executive order specifically looking at stimulus checks and exempting stimulus checks from garnishment. We've seen similar action taking place, perhaps with less teeth, from, for example, the Ohio Attorney General describing stimulus checks as a public benefit that should be exempt from garnishment. So that's one category of the kind of post-judgment emergency orders that we've seen. Another category is not just limited to stimulus checks, but thinking about garnishments more broadly. And that's really been the focus of a few different branches of government, including by executive order of the governor in Illinois, and by the judiciary in Virginia and a few other places that really put a pause on post-judgment actions, whether that was the issuing of garnishments or the processing of garnishment cases, or garnishment hearings rather, within the court system. Texas is maybe the most interesting of these, because they've already issued a stay on any kind of garnishment proceedings, and then already lifted that as well. So garnishment proceedings are moving forward now in Texas. So what we've seen here is kind of an array of different branches of government that are trying to tackle this issue in different ways. The one consistent theme that we've seen, however, is that very, very few states are addressing debt collection cases prior to judgment being issued. So a vast majority of what we've observed thus far has been tackling the issue of once a judgment has already been issued, the kind of post-judgment collections that are available to debt collectors. So what we want to tackle and unpack a little bit more is, how did cases get there in the first place? Are there actions that should be taken to make sure that fair proceeding actually took place and that both sides had an opportunity to be heard and have a ruling that was based on the facts? So, but before I turn to kind of the meat of what actually happens in a debt collection case, I'm curious if folks have any questions or responses or new information about this kind of post-judgment COVID response.
This is Ted. Erika, thank you for asking. I'll just lead off the way by saying that the state of New Mexico has just issued the Supreme Court has just issued an order stopping all new garnishment orders. So it's post-judgment as well.
Great, thank you. And I think we're going to see an evolution of this list, both in terms of states taking new action for the first time, and then also states either the expiration of these existing orders or the declaration of a new order that sets things back onto the same track as before. So this is something that I think is worth continuing to monitor, and we're relying pretty heavily on consumer advocacy organizations to share that information as well. But as I was, yeah, sorry, Elias.
Oh, it looks like there's got a raised hand here. Ali, go ahead and unmute.
Andy Liebenbaum, sorry. Go ahead, Andy.
Oh, I can't unmute myself. All right. So the question that I have before you get, so I really appreciate this, Erika. And one of the questions that I have, and it may become apparent, so you may say, we get there, no spoilers. When you're talking about consumer debt, are you specifically talking about debt that is not collateralized or insufficiently collateralized, or is it any consumer debt like a car where there is collateral? So that's my question.
That's a great question, and I think we will talk about it a little bit, but I'm happy to answer that now, which is just that even we're largely tracking how courts have themselves categorized cases, and that's generally been to include collateralized debt as well. The exception being housing. So we are not including foreclosures or evictions or other landlord-tenant related cases, even if there may be a failure to pay that may otherwise be categorized as a debt. We're considering those as a separate category. Sure. Yeah, so with that in mind, I'll start to talk about some of our key findings. And just as I said at the outset, what our project focuses on is on primarily courts, but really state and local civil legal systems and the kind of ecosystem of civil justice. And this is the first of what we hope will be a series of reports about court trends. And so what actually might be interesting to this audience is the first finding that we had was that looking at civil caseloads writ large, civil caseloads have actually declined. So we were looking at National Center for State Courts data, and after decades of year-over-year increases in civil case filings, we've seen a nearly 20% decline from about 2009 to 2017. So I think that was one of the first findings, and we're seeing a few researchers interested in exploring exactly what the causes are of that decline. That wasn't the focus of this report, but it's something that we're interested in exploring in the future. But I think that this is an important backdrop for the findings that that follow, which is that while other caseloads have declined writ large, there is of course a continuing trend of people continuing to have legal problems, right? So it's not that people suddenly stopped having problems that should be addressed in court or could be addressed in court. What we found in a survey that Pew conducted in 2018 was that more than half of all American households in a single year reported having at least one of 12 different potential civil legal issues that could have been addressed in court. And those range in terms of severity. So probably the more salient stat here is that 1 in 3 households had a debt issue, family issue, or housing issue that could have been addressed in court. So it's not that people stopped having legal problems, but they do seem to be using the court less than they did. The one area where we do see court users continuing to thrive is in the area of businesses bringing lawsuits against individuals. And so that's kind of a rough categorization here, but looking at the most recent national snapshot that's available, which is from 2013, more than half of all civil cases were brought by businesses against individuals. That's kind of a rough estimate here, because what we're categorizing there are mortgage foreclosures, landlord-tenant cases, which of course some of those could be brought by individual landlords, and debt collection cases. The category in red here is small claims, and small claims, as we all know, is a distinction made based on dollar amount, which doesn't tell you anything about the actual underlying dispute. So some of those cases, of course, are debt collection landlord-tenant cases as well. They just aren't categorized by courts. So what we've seen is both this kind of robust use of the court by businesses against individuals, and we've also seen, particularly with debt collection cases, that this is a rising trend. So in a 20-year period from 1993 to 2013, debt collection cases doubled both as a share of the overall caseload and in their raw number. They went from less than 2 million to 4 million cases in that 20-year period, and they're now the single most common type of civil court case, at roughly 1 in 4 civil court cases being a debt collection lawsuit. And here I'm talking about private debt. I'm not talking about government entities. I'm talking about businesses bringing debt claims against individuals. So while we didn't really examine the causes of that increase, I think it is important to note that same 20-year period also tracks with the growth of the debt buyer industry. So the graph that we're looking at now shows the sales of consumer debt at the kind of original estimated value of the debt that was sold to a third-party debt buyer, like Portfolio Recovery or Encore Capital or other third-party debt buyers. And that the face value of that defaulted debt sold to debt buyers has grown 1,500% in that same 20-year period as the growth of the debt collection lawsuits. At this same time, we were also examining the revenue sources for debt buyers as companies, and very few of them are publicly traded, but from what we can see, legal collections is a growing category for the kind of revenue that debt buyers are, where debt buyers are investing their resources, and also where debt buyers are recouping on these debts. So legal collections includes litigation. It also includes demand letters or other activity that would be engaged in by an attorney on behalf of the debt buyer. So we certainly see a correlation here between the rise of the debt buyer industry and the rise in debt collection lawsuits. There are other causes as well, including the rise in household debt and other areas that we haven't really tackled. Folks have questions about this part?
What's with the extreme variability in the 2000 to 10 period? Just the post-recession stuff? Well, it's pre-recession, most of that.
Yeah, it's pre-recession, which I think is really interesting. I'd love to tackle that further. I don't have an answer on that one, but I think that's a pretty dramatic spike. We do see a kind of through line of an overall trend here, but certainly there's a spike before the Great Recession as well. And so what's unfortunate about the national data, both in terms of this debt buyer industry data, but also in terms of being able to tell the kind of categories of civil filings writ large, is that the most recent data is from 2013. So what we did in for our report was look at state level data, and we tracked the annual statistical reports of all 50 states plus DC in kind of a list of years leading up to 2018 was the most recent year where we looked. And what we found was that only 12 states report on debt collection cases or debt claims as a category in any aspect of their court system. California is one of the 38 that does not. So what we have, the kind of rough categories here are general jurisdiction courts, so the higher dollar cases, that's where Arkansas, New Mexico, and Utah do some of the reporting. Limited jurisdiction courts, and then places that report on more than one jurisdiction, more than one tier of court as far as dollar amounts. And of those 12 states that do report on debt collection cases in any part of the system, debt collection cases were the single most common type of civil court case in 9 of the 12 among those jurisdictions that they're reporting on. So we're kind of piecing together a few different indicators, but what we can see here looks like the trend that we observed from 1993 to 2013 has persisted to the best of our knowledge. I think that tracks with what folks have observed anecdotally as well. So the problem is not just that there's a lot of these cases, right? The problem is what actually happens in these cases. So I'll talk a little bit about the findings here that I think will probably not be surprising to participants on this call. But from our perspective, what we're trying to identify are the common threads of what happens in a debt collection case and what that can teach us about business to consumer lawsuits more broadly, and also how the civil justice system is functioning more broadly. So the categories of what we're seeing here really call into question this conventional wisdom about what happens in a court case, right? So for many folks, they think there's a jury or at least a judge, two sides arguing the facts of a case with their lawyers, and the judge calling balls and strikes, here, taking in the evidence, taking in the arguments, and issuing a decision. And as many of us are all too familiar, that's not what happens in debt collection cases. What happens in debt collection cases is one attorney, often representing multiple plaintiffs, and no representation on the other side, and in many cases, no litigant at all on the other side. So I'll tackle those two pieces in turn, the representation and then the participation. We looked at previous studies underscoring the representation disparity between plaintiffs and defendants in consumer debt cases. And what we've seen was that at a maximum, the highest rate of representation that we've seen in any study was still less than 10%. Fewer than 10% of consumers were represented in debt collection cases. Compared to, in some of these cases, these are looking at a smaller set of plaintiffs. So in some of these, 100% of plaintiffs are represented, certainly more than 90% are represented. So the representation disparity should come as a surprise to very few of us, but continues to be very stark. And there are a lot of different potential explanations for the representation rate. But one of the concerns here is not just the representation disparity, but also the fact that few consumers are participating in debt collection cases at all. So in the jurisdictions that we've studied, the default judgment rate was more than 70%. So in more than 7 in 10 cases results in a default judgment against the consumer, which I think is really important, particularly for folks who are not as familiar with what happens in a consumer debt case, to understand that what that means, that the default judgment means that a debt collector wins without the court having any review of whether the right defendant was sued for the right amount, whether that case was timely filed, whether the case was valid in the first place. So there's simply no review of the case before that judgment is issued. And I think what we've found in conversations with folks who are not as familiar with consumer debt cases is that that's really surprising, right? That's not what you expect would happen in a court of law. What that also leads to is the fourth finding here, which is that despite the fact that a default judgment is issued without any review of the facts of the case to make sure that the right person was sued for the right amount, default judgments carry the same weight as any other court judgment. And so we outline in the report some of the kinds of court costs and fees, meaning, for example, that attorney's fees, interest, and other court costs can sometimes exceed the amount of the original debt. We talk more about wage garnishment and seizing of assets. And then we've identified a few more extreme cases of civil arrest and incarceration. So civil arrest is authorized in 44 states in this country. And incarceration is certainly rare, but is observed. We've folks at the Maryland Volunteer Lawyer Service and others have documented cases of folks who have been arrested for contempt of court for failure to abide by a court order to pay, which is a distinction perhaps without a difference for many between the failure to abide by a court order to pay and failure to pay. So the last finding, I'm happy to pause there if there's other questions about the consequences or the pieces of the puzzle here. Our last finding was really focused on the data, and this is where I'm particularly focused for kind of future work, is looking at what we can learn more about court cases and how they differ across from state to state. But as I said a little bit earlier, there are 38 states, including California, that do not report debt claims in their public annual reporting. 12 do as of 2018, and of those 12, only 7 of them have reported over a 5-year period, so starting in 2014, which really makes it challenging for us to be able to observe trends. And remember that these are folks who are reporting on one aspect of their court system. So that doesn't mean that they're capturing the bulk of debt collection cases. They might be looking at general jurisdiction cases, which maybe have a starting threshold of $10,000. And if we're looking at cases that are largely $5,200 or less, that's not going to capture those kinds of cases. But still fewer states, only Texas and New Mexico, report on case type breakdowns, including debt collection cases, and outcome breakdowns, including default judgments. But most importantly, a single state, only Texas is the only state that reports on all types of cases, including debt collection cases, all types of outcomes, including default judgments, across their caseload, from the smallest dollar amount to the highest dollar amount. That small claims category is really, really the bear for most jurisdictions to be able to report. So we have really limited data here, which is why what we're arguing for in terms of the next steps, getting access to court data, is the #1 most important part of this for us. So I can come back to this slide summarizing the key findings if helpful, but I do want to tackle the steps that we've observed that states are starting to take. I think some folks on this call have actually taken in California and around the country. Good. Okay. So we did a scan of the kinds of steps that courts have begun to take policy-wise, but I think this first step of beginning to track and report on debt claims data, I think, is one of the most interesting. So the fact that we went from 7 states in 2014 to 12 states that are starting to track and report on debt collection cases is promising to me about both the interest of state leaders and the potential to actually be able to learn more about what happens in debt collection cases and how they can be different. The next step, and the one that I'll talk most about, is really looking at the policy landscape and making sure that both sides have an opportunity to be heard in debt collection cases and in other civil cases. And then the last step that we've seen courts start to take is we're describing this kind of catch-all of modernizing interactions between courts and users. And that focuses a little bit on technology, but also more generally on recognizing the fact that today's modern court user, particularly in debt collection cases, but also in a vast majority of civil cases, at least one side is not going to have a lawyer. So recognizing that today's modern court user is likely somebody who doesn't have counsel, what is the information that's necessary to make sure that that litigant can proceed fairly with their case? So we're looking at providing procedural information. We're looking at providing options and explanations of choices that litigants can make through the course of their proceeding, and also looking at how technology can be used to improve those interactions. But I think the one that I'm really interested in hearing the discussion about with this group is the middle one, the policies. So we documented about a dozen states that have taken some kind of policy reform in the past 10 years. States that are missing from this list but should be added are Illinois and Washington. But the kind of 3 categories here that we've identified are making improvements to notice, ensuring additional documentation to ensure that a debt is valid before issuing a default judgment, and then strengthening prohibitions on bringing cases that are outside of the statute of limitations. But again, because of this lack of court data, we really struggle to identify which states, which of policies that have been enacted in different states are having the strongest impact. So for example, North Carolina is one of the states that has had documentation requirements since 2009. And North Carolina is also one of the 38 states that doesn't report on its debt collection cases, so I can't tell you how it's working. We've also seen, Maryland, for example, has by court order changed the notice requirements to make sure that when third-party debt buyer is bringing a lawsuit, that it actually identifies what the original debt was for and who it was from, so that a consumer can identify whether it was debt that they actually owed in the first place. So we don't know if that's having an effect either. But but really interested in hearing more about what actually happens on the ground in California and whether the policies are having an impact and how that compares to other states as well.
Hey, Erika, this is Claire in California, and just to let you know that I've done a fair amount of data collection in California, and it looks like the Fair Debt Buying Practices Act did have an effect in 2014. We did see a drop, but that drop was also consistent with the enforcement actions of the CFPB against Encore and Medlin. And then we see a spike back up, and actually the last 2 years we see more filings than even during the recession, but we also see an increase in original creditor lawsuits, and the original creditors are not covered by the verification requirements and the evidentiary requirements of the Fair Debt Buying Practices Act. So we certainly see adaptions in the debt collection industry following legislative and enforcement attempts to regulate.
Thank you, Claire. Yeah, and I should say at the outset, like a lot of these states have parsed their case type here. So whether that's only referencing third-party debt buyers, assignees. Some of them, I think Massachusetts has a limitation on credit card cases, which includes original creditors, but is still kind of segmenting of the debt collection cases when it comes to these new policies that makes it a little bit challenging to compare apples to apples.
Question from Robin Smith.
Hey, this is Robin Smith. The quick question is, on your prior graph, you were looking at different sort of issues, including procedures. Are you looking at all at legal services and the impact that lack of free legal services has on ability of people to defend themselves in these cases? Just because I see that as a very important part of these kinds of questions.
I think that's really important, Robin. I think one of the pieces of information that's not readily available is representation as an aggregate statistic, right? So if we saw the representation rate and we're able to compare jurisdiction to jurisdiction, that would tell us a lot more, right? If we could combine both representation statistics and information about the policy landscape with what's actually happening in the cases in terms of default judgment rates or even filing rates, I think we could learn a lot more about what's effective as a matter of practice in addition to policy change.
Oh, so sorry, one last question. Do you know of a way to do that? Is the data just not available? It seems like that would be a really hard thing to figure out. So
I think it's getting better. And I'm really interested to hear what Claire's seen from the California data, because what we've been looking at is, as a starting point, what's already aggregated and reported by state judiciaries themselves. But I think what comes next is being able to assist with that kind of categorization. So in a place that doesn't already categorize debt collection cases, but would make available party names, we could absolutely categorize cases into debt collection cases, right? That's something that we could collectively do. And I think the same thing is true for docket information and representation statistics. A court could either report in aggregate on representation rates or could share information in individual cases that would enable us to do that. And I think there's a growing interest among state judiciaries in understanding, particularly right now, as they're trying to figure out what happens when they open up courthouses again, and what kinds of cases, what kind of backlog they're anticipating coming in, to be able to assess their own caseloads better and to assess how to process those cases. So there is potential for mutual interest in improving the kind of data availability.
Especially since, when legal aid folks do get involved in these cases, or when attorneys get involved, these cases don't tend to take as much time on the court dockets, or at least they can make the court cases a lot easier. Depending, yeah. It depends.
That definitely depends. But what we did find was that cases, and this I'm sure would not be a surprise to folks, but when consumers are represented, they're more likely to either win their case outright or come to a mutually agreed upon settlement with the other side. So I think there is certainly an argument to be made here that there's a common interest in having both sides represented. The other piece of that, of course, is just having both sides actively participate in order to have a fair ruling based on the facts, right? So I think that that's hopefully not a controversial statement.
Thanks, Erika. We have a question from Marjorie Murray.
Yes, Erika, I'm wondering if you in your research have identified any incentives across the states that would make courts, first of all, collect data and to collect it in a way that is consistent with other states so that you could arrive at some trends. I mean, are there, for example, funding incentives or some other kind of incentives that would impel the states to collect the data in the first place and to collect it in a consistent way so that you could see trends and patterns?
You don't think just saying please really nicely will do it?
Pardon?
You don't think just saying please over and over again will?
Oh no, please is not gonna. That's probably not going to do it. No.
Well, so I
think you're going to need some carrots.
Yeah, I think that's a fair point, and the idea of like what kinds of incentives, particularly when if you're talking about something that might be a heavier lift for courts to overhaul systems or data collection mechanisms. But what we have seen is I don't know if folks are familiar with the National Open Data Standards Project. So the National Center for State Courts. And I think the Joint Technology Committee, which is this coalition of leaders from court management, state court administrators, and maybe Conference of Chief Justices, have put out they've identified what data variables they'd like to encourage their state counterparts to collect in a way that is consistent to be able to do that, exactly that kind of examining trends and examining more apples to apples comparisons between jurisdictions and across jurisdictions. And you can check that out at ncsc.org/NODS. It doesn't quite get to the incentive question, but it is kind of the peer-to-peer incentive, I guess, there.
Thanks, Erika. We have a question from Rebecca Morse.
Thanks, Ted. This is a question born of my ignorance, and that thank you so much for this presentation. But are there no sort of federal avenues for forcing data disclosure, like an SEC requirement that like publicly traded debt collection companies at least report like in the aggregate on lawsuits filed or money collected, or like as part of some, there was similar stuff in the Dodd-Frank bill for other industries, which is why I
so what they have, what the publicly traded companies, unfortunately, there's very few of them, but for us to be able to even do a lot with it, although they are very large. What they do report on is this category of legal collections, and we're kind of assessing that to mean primarily litigation, but it doesn't exclusively mean litigation. I think that's the issue, is that it's just a larger umbrella. So they do have to report on it, but it can include other actions that are taken by a lawyer.
Okay, so it's not disaggregated enough to be useful.
It's still interesting to see, right? The percentage of a debt buyer's portfolio that is legal collections is very, very high. But it is like, it would be helpful to disaggregate it further to be able to see how much of that is coming actively from a court case.
Got it.
The other related, so that's thinking about the plaintiffs themselves. I'm also thinking about incentives and obligations for courts. The Bureau of Justice Statistics requires for court reporting or the availability of court data on the criminal justice side, and we have a lot less in terms of civil justice data, which is part of why we have so few national snapshots.
While others are getting their questions together, and please do make sure that you ask, you can raise your hand or you can put something in the chat, but raising your hand is the easiest. Your blue hand, that's on the participants tab. Let me ask you this question, Erika. Aside from looking at California with respect to reforms, and Although it was far from perfect, we would argue that the Fair Debt Buying Practices Act also included improvements to notice, even though you gave us a blank spot.
I knew it.
That you know, what else did you learn about California itself? I mean, or perhaps what did what did the data that you were able to gather separately from 58 separate courts or whatever it might have been, what did it indicate? What do you see in the state, and obviously what might we consider?
Well, I think, so one of the things, and I'm actually interested in hearing Claire's perspective on this as well, but one of the things that we've observed is this kind of compartmentalizing of debt buyer cases from other kinds of cases, and wondering like what are the steps that states can be taking to address the debt collection lawsuits regardless of plaintiff. I think that's one concern we've seen. I think one question that came out of our research that I'd love to get folks to respond to a little bit is the kind of, we described on this slide as prohibition on suing on time-barred debt. Thinking about like what the consequences are of bringing expired or time-barred cases forward in a court case, and whether there are actions that can be taken by the court itself rather than expecting consumers to be able to have these as affirmative defenses. And I think that, so those are two. I'll start with that, but I see Claire has unmuted, so I'm curious what she says.
I'll just jump in quickly that having asked the 58 counties in California for this information, I was surprised to learn that at the county level, the majority of counties who responded to my request for information, or that we did data portal scraping on, you could track this information in the docket. You could determine what were debt collection cases and what weren't. So I'd like to second what Erika said, that if the state were to ask for this information, we would get significantly more information. And then the second thing is, in California, almost all of the counties use a third-party court management system. So there was a normalization of data that then needed to happen. And we found that one of the things that was most difficult to track were self-represented litigants, because most of the court systems track that differently. So an unrepresented litigant may not be the same as a pro per litigant. So when the courts would return information about pro per litigants, it's only those people who actually like wrote in pro per on their answer. So there's, I think the Open Data Standards Project is really important, talking about normalization of data fields, because what we call a piece of data, has a big impact on how we're reporting it, to make sure that we're all reporting the same thing, especially in this multi-jurisdictional analysis that like Pew is doing, right? You guys had to take all these different systems and normalize that information. And I just want to add one more thing, which is another thing I asked all the counties were the involvement of self-help centers or legal aid offices. And there's this huge disconnect between the self-help centers that exist in every single one of the 58 counties and then the court management tracking system, because the court management tracking system is focused on, efficiency and case management. But like, as Robin asked, what about the involvement of legal aid? A lot of legal aid and self-help centers do unbundled services. And so it would be really valuable if we're making normative recommendations at the state level that county courts also track the involvement of legal aid offices and self-help centers, not just full representation, but also the unbundled services component, because that's oftentimes the way that, that legal aid gets involved in debt collection cases.
Thank you, Claire. Robin Smith, another question.
All right, sorry, trying to figure out how to unmute. So a couple questions, just following up on what Claire said. I think too, it's important to track what happens to people in self-help versus represented cases, because while I personally don't think self-help is that helpful in debt collection cases, but maybe I'm wrong and you might find something else. So I think there really needs to be a breakdown in those two areas. But the second question I have is, in the states that track this data better, is it something that's legislatively mandated, or is it each court deciding? Like, how in California could we work on trying to get that kind of reporting throughout the state?
That's a great question. So just as an aside, when I worked in the courts in Massachusetts, we instituted a little stamp that we would put on all any document that was submitted to the court that had the assistance of the self-help center. And we tried really hard to have that added as an actual variable, actual code that would be put into the case management system, which would make it more meaningful, not only to be able to say that someone had the assistance of a self-help center broadly, but that they had the assistance within actual, pleadings or court forms of different kinds. It never happened. And I think I have the same question that you do about the role that self-help centers are playing in debt collection cases and in other cases. The question about court data reminded me that this, the slide that we have up right now about state reforms, some of these were by statute and some of these were by court rules. So we have a table in the report that highlights the difference between which ones are statutory and which ones are by court rule. But when it comes to data collection itself, which was your question, Robin, my understanding is that these are largely driven by administrative offices or Supreme Court statistical reporting. Some of them, like for example, I believe it's Iowa, only produces reports at the request of the legislature, and they're not posted on their website at all. They don't collect debt collection data, but I mean just at all, any of their statistical reporting. So I think that I haven't seen statutory mandates that have created this additional data reporting, although that's not to say that they don't exist. But I do think that there's more of the kind of other incentive of like informal or formal requests from other entities, whether that's the legislature or executive branch, that can generate new reporting. But I do think that's largely coming from the judiciary itself.
Other questions for Erika? Erika, let me ask you this. In terms of what you have seen in other jurisdictions around the country, and with an eye towards your best guess, improving the percentage of folks who are represented in cases, whether it's Texas or otherwise, what seems to be driving the places where representation is highest, and what sorts of policies are in place that make that work?
So as a starting point, we don't have robust data about representation differences enough to be able to say writ large across the country that places that have certain policies are stronger. I think, you could, even the argument that like places with higher funding levels for legal aid, they may not have higher representation rates for consumer debt cases because there may be different priorities or even funding streams that are resulting in case type selection by legal services providers that are not necessarily going to tell you exactly whether they're representing folks in consumer debt cases. I have seen some suggestion that the fee shifting statutes is one avenue, in addition to legal aid providers, for increasing representation in consumer debt cases. So thinking about models where there may be counterclaims that can be brought against debt collectors that themselves can generate fees for the consumer's attorney that comes not from the consumer themselves, right? So we don't have robust data to see even the numbers of those cases is relatively small, but it would be really interesting to be able to compare states that have a high number of fee shifting statutes that are both not just the federal statute, but also state statutes that can expand those kinds of practices for folks, whether they're within legal aid organizations or as private practice. But I'd be really interested in seeing whether that's makes a significant difference.
Are there other? I'm going to pause a moment so someone else can ask a question. But seeing none, are there other measures that you in your research and have seen, at least out of the corner of your eye, that you think that you wonder whether that policy might have a sort of salutary effect in getting towards I think that you implied that sort of the model of having both sides represented in an action where the court is actually weighing the facts and making a decision.
So what we have seen is more engagement from courts in providing tools for consumers to be able to represent themselves, and we don't have data to be able to say that improved outcomes for folks. But I think whether that's increasing participation, we have a little bit of data there. So from my Access to Justice Lab days, seeing providing self-help tools to folks increases the response rate. So we in one study in Boston, we were able to double the rate of consumers that were responding. And the parameters of that study were these were consumers who would have access to a volunteer lawyer for the day once they got to the courthouse. So we weren't tracking whether they ultimately got represented, but the assumption was that they could get represented by counsel. But sending folks information about what they're filing an answer, in that case you had to file an answer, and providing people with kind of clear instructions about how to do so and where to go to court, doubled the response rate. So that means it went from, I think, a 7% response rate to a 15% response rate. So we're still talking about 85% of cases defaulting. But it is possible to make a difference in increasing participation. Whether that actually resulted in better outcomes for those litigants, we didn't study.
Did you ever, in the course of your studies at the Access to Justice Lab or otherwise, come across the answer to the question, why are so many people unrepresented in these cases? So we've had a lot of people ask the question. There's a lot of speculation. I think so part of it is people not responding to the lawsuit at all, right? It's not the folks kind of, there's a little bit of a chicken and the egg there between someone not being able to find an attorney and therefore not participating in the court case, or not participating in the court case, not bothering to look for an attorney, right? So I think some of each of those things happen. But one of the, so we do have studies that suggest that folks aren't pursuing responding to these lawsuits at all, let alone looking for counsel, because they didn't actually receive notice of the lawsuit, or they received notice and didn't recognize the name of the company that was suing them. So they're not, so it looks like not a legitimate lawsuit, not a legitimate piece of paper to respond to. Of course, the costs associated, I think, are one significant piece. So we're talking about folks that are low income, moderate income, middle income, that are subject to debt collection lawsuits. And we're talking about lawsuits that are, I think the stat that we have, I think, is that the 70th percentile or so of these cases is around $5,000. So we're looking at a lot of cases for $5,000 and less. So if folks are either, whether it was a legitimate lawsuit or not paying a $5,000 or $500 lawsuit, they're also not paying for counsel to respond to that lawsuit. The question of whether there is a legal aid attorney available, I think, is still an open question there. And I think, as we all know, it's not that legal aid attorneys are waiting for clients and not able to find them. So it's the kind of scarcity of free and low cost legal resources, lack of understanding, lack of awareness by courts, by attorneys, by consumers of the availability of limited scope limited scope or brief advice, I think are all kind of a combination of factors. But which is the dominant factor is really, we don't have evidence on that yet. Thanks, Erika. So our last two questions are first from Andy Liebenbaum and then from Robin Smith. Andy?
Thanks, Ted. So the issues surrounding data collection in California's 58 courts is a subject unto its own, I think, webinar. But it is something that we grapple with. So I work for the Judicial Council, full disclosure, and so data collection is something that I confront on a regular basis. I know that you're trying to look at the upfront filings, but wouldn't wouldn't there be some way of gathering data by looking at enforcement of judgment actions?
Yes, absolutely. And I think the policy differences from state to state in whether enforcement requires coming back to court or for the judgment creditor, or coming back to court for the judgment debtor to contest really varies. And that was one of the challenges for us to be able to make judgment calls about, you know, good case number, good volume and bad volume, and that with those differences. And we're seeing that difference play out in the pandemic as well, which I can talk about if folks are interested. But I do want to say, don't lose hope. 58 may sound like a lot, but Texas is a decentralized court system that has hundreds of different little fiefdoms all over the state, and they're able to share information and compile it into a place that the administrative office of the court can.
Right, so they have a single case management system. We use, many of the courts in California use the vendor that is the Texas vendor. That is one of many vendors in the state of California. So the difference isn't just numbers in California. It's the fact that the legislature, among other actors, has prevented the courts from having a single unified case management system statewide.
Thanks, Andy. And Robin with the last question.
Yeah, have you been able, or do you think there's a way to disaggregate the data by zip code? And I'm just wondering how we get at sort of what are the racial, what are the different implications for who is impacted most in these kinds of cases, and if they aren't being able to sort of defend themselves?
Yeah, that's important. And we did highlight in the report one pretty small set of studies. I think it was by folks at ProPublica in a handful of cities, St. Louis and Newark, and I think Chicago, that looked at racial disparities in both filings and also default judgments in debt collection cases. And of course, they saw very disproportionately high rates of default judgments in predominantly Black neighborhoods, looking at, I believe, using geographic data the same way that you're describing. If we getting kind of case level data the way that Claire was describing would enable us to get zip code information. Right now, we were looking at higher level aggregate data, so we didn't have zip code information.
All right.
It's not insurmountable, but it does involve multiple steps of like data cleaning and pulling proofs of service, for example. And then that only is the geographic data for the people who are served, because you don't have a zip code for the folks who, when it was sewer service, or if it wasn't actually service and it didn't actually get to the person. So there are a number of issues, but I'd be happy to talk with Robin or Ali or other folks in California who are interested in California data collection, because I'm certainly working on these issues.
All right. Well, we are at the top of the hour. I want to say thank you very much to Erika. I want to thank everybody for attending. Let me say a few things. First, if you are interested in continuing this conversation in California, and maybe we'd even convince Erika to join us at some future point, please email me. Let me know if you would like to be part of a somewhat smaller and or not discussion of what we can do in California to improve our own court system and move one that much closer to justice writ large. Second, we will send around to you. A number of folks have asked about the recording. If it's possible, we will we will send you the recording. If for some reason we are unable to do that, we will let you know where to find it. And finally, please keep an eye on this space for other entries in our summer series of economic justice events. So again, thank you everyone for attending. Erika Rickard, thank you tremendously for leading this fascinating discussion, and we hope to continue it. Have a good night, everyone.
Thank you all very much.
Thank you.